For those of you who do not know me, I'm Steve Looney. I'm chair of Dean Mead's corporate and tax department. And for those of you who do know me, fortunately or unfortunately, you may think it's a bit ironic that I'm going to be spending the next 50 minutes or so speaking about LLCs, because as you may know, especially my partners, I happen to be a little outspoken proponent of S corporations versus LLCs taxed as partnerships. But I'm not going to disappoint. Before we get started, I am going to make a point. Just keep in mind that although you can be a state law LLC, you can still elect to have that LLC taxed as an S corporation. And I did want to point out I know this isn't a tax seminar, it's more state law, but I did want to point out that there has been a very recent pronouncement by the IRS where they've adopted a line of cases recently, basically holding that at least in service LLCs, a member of the service LLC cannot be treated as a limited partner for purposes of avoiding the self-employment tax, which again points out another distinct advantage of S corporations over LLCs and partnerships. We'll give Charlie rebuttal time a little bit later for partnerships. Anyway, again, for the next 40 or 50 minutes, I'm going to be focusing on the new LLC Act. And I am just going to point out a few of the highlights, really, of the new LLC Act. We don't have time, and I should point out that the outline doesn't cover all the changes, but we're going to try to take a look at most of what what I think is the most important changes. A little later, after I've talked about the LLC Act, Jane's going to cover the applicability of the new LLC Act to nonprofits and charitable LLCs. And then she's going to get into a whole new area under 607 that deals with social purpose corporations as well as benefit or B corporations. And just to keep my partners on their toes, as well as hopefully breaking up the monotony of just having me speak, I am going to call on a couple of our partners to comment from time to time on some of the provisions I'm covering today. Well, with that, let's go ahead and take a look at the new LLC Act. And the important thing to recognize right off the bat is they didn't just amend the existing LLC Act, which is Chapter 608, but what they did do, they enacted a whole new Chapter 605 that contains the new Florida Revised LLC Act. And I just thought I'd throw this little cartoon in here that now we got the new act. I guess we can say we have an LL Cool C, but it's cool for some reasons, for some members, and it's not favorable for other reasons, as we'll see as we go later on. Basically, this Chapter 605 took a period of like 4 years to come about. It was really a combination of different committees of the Florida Bar, of which I was not a part, I might add, in case you don't like the act. And it resulted in a lot of compromises. There was a lot of input from banks and creditors in general, and you'll see where there are some favorable provisions to creditors that didn't exist under the prior act. Again, there's a lot of favorable changes, but also some unfavorable changes. As far as the effective date, any LLC that's been formed this year in 2014 is subject to the new Chapter 605. Additionally, come January 1, 2015, and this is what's really important, all those LLCs, you as clients or you advisors out there that have clients that had pre-existing LLCs, all of a sudden Chapter 608 will be repealed and they will be subject to the new provisions of Chapter 605. There's no grandfathering that they get to continue to use the old LLC Act. Just a couple of things. I wanted to point out one thing that the LLC Act does not change and carries over from the old Act is the so-called Olmstead patch. And I think that's just because that was something that was of great discussion. I wanted to point that out. I think it's on the first page of the outline. And the Olmstead Act was, or patch, was enacted by the legislature in order to counter the decision in Olmstead and clarify that a charging order of a creditor against a member of a multi-member LLC is the exclusive remedy for that creditor. He can't go and become a member. He can't get management rights. He really only has the rights of a transferee to distributions to which the debtor member would have been entitled to when and if distributed. Additionally, that same rule does apply to single member LLCs unless the creditor can demonstrate to the court that charging order won't be satisfied out of distributions within a reasonable amount of time. Again, as far as what this outline covers, it only covers some select highlights. I urge you to read the whole act. I know it's boring, but it really contains a lot of changes, and I just want to give you an example of that. Whereas the old act contained 26 defined terms, the new act contains 69 defined terms. And, you know, that's important in and of itself in looking at your operating agreement, because you may have used some terms that are now defined and they don't have the meaning you thought they had. And another thing that the LLC Act does, the new LLC Act, which is very important, and we'll talk about this later, it eliminates one of the definitions under the current act. It completely eliminates the definition and a concept of a managing member in a member-managed LLC. And as I'll discuss later, that creates some issues that will have to be addressed with respect to pre-existing member-managed LLCs. Now let's take a look at the effect of an operating agreement with respect to the new Florida Revised LLC Act. And really, everybody's familiar in the context of LLCs. The operating agreement is really the primary agreement that governs the relationships between the members, the managers, and the LLC itself. So that's, you know, everybody pretty much knows that, but what the new act does, and this is extremely important, it provides an extremely broad definition of what constitutes a operating agreement. It can be written, it can be oral. It's not subject to the statute of frauds, so you can have an oral operating agreement. Additionally, the new act also says it can include implied agreements, and I guess that might be from some kind of course of dealing. You might imply that the operating agreement has a certain provision, and it includes any provision contained in a so-called record. Well, records are defined pretty expansively also, really to mean any information that can be inscribed in a tangible medium or stored in electronic or other medium, so long as it can be retrieved in, quote, perceivable form. Well, to me that means if you have notes that maybe were made and signed by the members of the LLC, if you have emails going back and forth regarding the provisions of the LLC, all of a sudden all these provisions could be construed to be part of your LLC agreement. So the very first part, this is really important because of the broad definition that before one becomes a member of an LLC, you really need to do your due diligence, see if they have a written operating agreement, get representations that's the entire operating agreement, and if they don't have a written operating agreement, get representations as to whether there's any oral type of operating agreement or anything implied or contained in a record. And again, I think that puts the burden on the person becoming a member of the LLC to do his due diligence. The new Florida Revised LLC Act lists a number of, I think I may have went too far there, hold on. This is a touchy thing. Oh, there we go. All right. Basically, it provides that the operating agreement is the primary agreement. If it provides for something, that generally will control. If an operating agreement is silent as to, say, admission of a new member or something to that effect, well, then you have to look at the default rules in the statute, and those default rules will apply. some of those default rules have changed from the existing act to the new act that becomes effective January 1. Additionally, you should be aware, and we'll talk a little bit about this, but I'm not going to focus too much on it, that under current law, current act, you have 6, quote, non-waivable provisions that can't be changed by agreement of the parties, in the operating agreement or the articles. The new act expands that list to over 17 items. And although it says they are non-waivable, in certain circumstances, some of those are subject to limitation, are subject to modification, subject to certain limitations. The non-waivable provisions, I've listed the 6 basically under the existing act on page 3 of the outline, and then the 17 that are under the new act. Again, I'm going to just, several of these merit highlighting, I'm going to highlight those, but you really need to review each of those non-waivable provisions, then look at your operating agreement to see if your pre-existing operating agreement has waived something that now is non-waivable, so therefore would be ineffective, and you would need to amend the operating agreement to address that issue. Well, some of the non-waivable provisions, and this is pretty common, an operating agreement cannot exonerate or indemnify a manager or a member or an officer for any type of conduct that involves bad faith, intentional or willful misconduct, or a knowing violation of law. That would seem to make sense, but it's something to keep in mind. Additionally, the operating agreement cannot unreasonably restrict the rights of persons concerning the inspection of the records of the company. Now, there can be reasonable restrictions, and you would want to put those in the operating agreement if you want to limit a member's rights to inspect the records. The operating agreement cannot vary the right of a member to be able to disassociate, and we'll talk a little bit more, and I may have Charlie comment a little bit on this, on what disassociation means under the new act. But basically, now you can't prevent a person from disassosinating. There may be consequences to that, but any member can disassociate from an LLC. It's not possible under the new act, as it is under the existing act, to waive the right to judicial dissolution. Now a member or a manager has the right to bring an action to dissolve the LLC, and you can't waive that in the operating agreement. Lastly, I just want to mention, as far as the non-waivable provisions go, you cannot unreasonably restrict the right of a member to bring a direct legal action against the LLC, a member, or a manager, or from maintaining a derivative action. So again, just some concepts to keep in mind. Now, here's where it really gets interesting, and that is who's bound by an operating agreement. And keep in mind, again, we could have a written operating agreement, we could have an oral, and all these variations of that. Well, first of all, the new act tells us that an LLC can enforce an operating agreement even if it is not a party to the operating agreement. And I think that was pretty standard even under existing law. A lot of times we did not make the LLC a party to the agreement, but nevertheless, this expressly provides that the LLC can enforce the agreement even if it didn't sign the operating agreement. On a much more scary note, and I'm not exactly sure of the reasoning of this and why this was enacted, but, and it really goes against everything I learned in law school about contract rights and being bound by contract. When you become a new member of an LLC, you can be bound by the operating agreement even if you do not sign that operating agreement. Well, that's really strange in my opinion, but that is here. And again, that just emphasizes to you, you need to do the due diligence. If you're representing somebody or you are a member, becoming a member in an operating agreement, ask them if they have a written operating agreement, ask them if there's any other agreements, get a representation as to it, And, you know, I would become a party to it if you're agreeable with it, but obviously if you don't agree with the terms, you wouldn't. But I think this is just a big trap for the unwary because, you know, again, I, even as an attorney, would normally think, well, if I become a member here, but I don't sign the operating agreement, I'm not going to be bound by its terms. Not true under the new act. So something to really watch out for. As far as, and again, I point out that the agreement is not subject to the statute of frauds except with respect to capital contributions. Oops, here we go. This is just a little cartoon. It shows a couple of members of an LLC. They get their hands tied behind their back and they're saying, gee, I didn't know we could be bound without our consent. Well, unfortunately, they can be bound by managers, and as we will discuss, they can also be bound by members under certain circumstances because of the statutory apparent authority that managers have with respect to manager-managed LLCs and members have with respect to member-managed LLCs. If you'll look over on page 5, I think I went the wrong way again. Okay, I got to go backwards. As far as a manager-managed, or no, this is a member-managed LLC. No. Okay, existing law is carried over to provide statutory authority for all members in a member-managed LLC, but only for managers in a managed LLC. So if you're in a manager-managed LLC, a member does not have any type of statutory apparent authority to contract on behalf of the LLC. Now, what we have as a completely new concept in the LLC Act, and one which I think is going to become very much used, although we've talked to a few people. I think Vicki Berman and I got on the phone with a title company representative, is there's this new concept of statements of authority. And statements of authority, again, I think are going to become the norm for third parties dealing with LLCs. A statement of authority allows the members of an LLC to file this statement with the Department of State that expressly authorizes who can have the authority on behalf of the LLC to enter into contracts, and likewise it can specify who doesn't have the authority and specifically limit those persons from doing that. A statement of authority basically gives constructive notice for those dealing with the LLC, and they're really entitled to rely on that. The third party can rely on that statement of authority. Now, a statement of authority is only good for 5 years. Obviously, if there's a change within the 5 years and you switch up and somebody else is going to have the management authority, you're going to want to amend that real quickly because that does serve as constructive notice, and again, third parties can rely on it. And again, at the end of the 5-year period, of course, you'd want to file a new statement of authority. A few more items about statements of authority. There are really two basic classes of statements of authority. One's dealing with real property and then all other statements of authorities. If you're not dealing with real property, the statement of authority to be effective only has to be filed with the Department of State. For a statement of authority, for instance, granting the right of a member or a party to convey real estate of an LLC, not only does that statement of authority have to be filed with the Department of State, it also has to be filed with the Recorder's Office. Now, once it's filed with the Recorder's Office, again, it's constructive notice, and the third party, in the absence of very limited circumstances, is absolutely entitled to rely on that statement of authority in dealing with that person specified in the statement of authority. I will say, as a member, you may have been designated as someone having a particular authority. For one reason or another, you may want to revoke that, and they have something called a statement of denial where a member can file that. It's treated as an amendment to the statement of authority. So again, that constructive notice would be part of the record, and that person would no longer have the authority. But I think the important thing here is I'm going the wrong way again. Okay. The important thing about the statement of authority is I really think that, and we'll talk a little bit more about the fact that in, as I said, in member-managed LLCs, any member has statutory apparent authority. I know how banks are. They're very thorough. I don't know if we have any bankers here. I'm a banker. And I don't know if you guys have talked about this. When we talk to the title company, they're aware of a new act, but they really haven't talked about statement of authorities. I tend to think that third parties are going to come to rely on statement of authorities, and anytime they do transactions are probably going to require the LLC to file a statement of authority, because then they have absolute assurance that they can rely on that and can't be second guessed. Next area talked about in the new LLC Act is just the vicarious liability shield, and that just basically says that members of an LLC are not personally liable for the debts and obligations of the LLC itself. That hasn't changed. It carries over. You've probably all heard of piercing the corporate veil, or here it would be piercing the LLC veil. Well, what the Act does provide, which is helpful, is it expressly provides that a mere failure to follow corporate or LLC formalities will not result in a successful attempt to pierce the corporate veil. It would have to be something more egregious than that. So that is helpful that that's now been put into the statute itself. And that is in that slide. Omission of members, really I'm just talking about, when we talk about this, I'm looking at the default rules. Your operating agreement or articles of organization can have any number of requirements about who or what percentage of members or managers have to approve to admit a new member. But if it's silent, it's interesting because under the existing LLC Act, it only takes a majority in interest of the members to admit a new member. But under the new Florida Revised LLC Act, if you're silent, it requires unanimous consent of the members to admit a new member. So again, something to look at your operating agreement. Have you addressed it? Haven't you addressed it? And, you know, by all means, if you don't have an operating agreement, this is a change in substantive law that, you know, wasn't there before. Another very interesting concept, and again, this was probably as a result of the compromise, a lot of bankers and creditors were involved in the revision of this act, is there's now a completely new concept that wasn't around in the existing LLC Act, and that is for non-economic members. And a non-economic member is a member that does not have any type of transferable interest. He has no right, you know, to make contributions, but he can have a right to vote. And where you see this is many times lenders will require a loan to be made to a single purpose LLC. And a lot of times the lenders will want to have some representation with respect to that LLC, and this new statute now expressly authorizes that member to be a member, have rights of approval as you prescribe those rights, but yet not be an economic member in any way and not be subject to, you know, any liability that other members might be liable for. So that's a very useful concept, again, primarily for banks and other lenders, but, you know, it's helpful because they do demand single-purpose LLCs a lot, and this was something that did come into about, and it was not addressed by the existing act. As far as contributions go, just a couple of changes made in the contribution area. As far as what is valid consideration for a contribution to an LLC, they did add the fact that permissible consideration now also includes a promise to perform services in the future. That was not in the existing act. Now, another, and this should be noted well, number one, a member is obligated to be enforceable. a provision requiring additional capital contributions to an LLC does have to be in writing. That's the one thing that can't be oral or it's not going to be enforceable. It has to be in writing to be enforceable. But if it is in writing, it's binding on the member who agreed to it, and it's also going to be binding on his successors if he passes away. And not only can it be enforced by the other members, but that obligation to contribute can be enforced by third-party creditors. Again, this is where we see the banking influence come in. And I think the importance of this is you really need to look over your operating agreements very carefully to see how that additional capital contribution language is worded. I know in some past LLC agreements, there would be a mandatory contribution if there were shortfalls in mortgage payments or real estate taxes if it was an LLC owning real property. I would advise you change those so that it at least requires the approval first of a majority of the members or possibly even a supermajority of the members, because otherwise a creditor could step in and force that contribution that these guys might not otherwise make and leave them worse off from an economic position. So again, a new right granted to a non-member, a non-party of an LLC agreement, a creditor that you need to watch out for. Distributions, I will just say the distribution rules as well as the rules for allocations and profits or losses and these are just the default rules. Again, you can obviously specify this in your operating agreement, how distributions are made and how profits and losses are allocated, subject to certain tax provisions, which we won't get into. But the default rule, if you don't provide for it, under current law basically says, well, you look at the value of the contribution of the members in making distributions and allocating profits and losses. But you don't take into account any return on those contributions. Make sure that's right. Right. No, it does take into account, excuse me, the existing act takes into account any returns of capital contributions. So it really looks at the time, what was your capital contribution, relative capital contribution less any capital contributions returned to you. Under the new law, for both allocations of profits and losses and the distributions, if you have no provision otherwise providing, the default rule is you simply look at the contributions of the members, you make distributions in proportion to that, you make allocations of profits or losses in accordance with those contributions without taking into account any subsequent return of capital contributions. So again, a substantive change you need to be aware of if you haven't already specifically spelled out in your operating agreement how distributions and allocations and profits or losses are made. And again, like I said, it changes the rule a bit. Another interesting issue dealing with distributions, just like current law, an LLC, much like a corporation, is prohibited from making a distribution, which would include a redemption, if that company is insolvent. But what the LLC, the new Florida Revised LLC Act does, is it adds two definitions for insolvency. One is really the inability of the LLC to be able to pay its debts as they come due in the ordinary course. And then a second test is whether the company's total assets would be less than its total liabilities, plus if it were to dissolve at that point, the amount of distributions to be made to those members who have preferential distribution rights in excess of those to whom the distributions are being made. Now, important point. The second requirement can actually be, that's a provision that can be modified or eliminated. So if you don't want to be subject to that second test and you only want to have the insolvency test not being able to pay your debts as they become due, you want to expressly provide for that in your operating agreement. Now, getting into some of what I think are the more interesting topics, we deal with, well, I went the wrong way again. Okay. Now we're going to deal with management of an LLC. And just like current law, you have two types of LLCs. They didn't change that. New Chapter 605 is the same as Chapter 608. You have manager-managed LLCs, and you have member-managed LLCs. However, as I pointed out before, a huge difference is in the new act, they have completely eliminated the concept of a managing member of a member-managed LLC. And as we'll talk about, that's going to create some problems, and we'll talk about how to address those, or at least it creates potential issues that we'll need to talk about. The Act's also very clear that unless you specifically provide in the Articles of Operating Agreement that the entity is manager-managed or managed by managers or, similar language, it's member-managed. And it also says if you have a pre-existing LLC agreement and it uses the term managing member, it's automatically deemed to be a member-managed LLC. So we're going to have lots of these pre-existing member-managed LLCs for which we've drafted agreements out there, for which we've named managing members. The rationale of the committee in eliminating that concept was they thought the concept of managing member created a lot of confusion. Well, perhaps it did, but for those of us who I would like to think were using it correctly in member-managed LLCs, it wasn't confusing, and this change is going to cause a confusion and changes to be made to the operating agreement. Yeah, Charlie, come. We're going to have Charlie Edgerton come here and make a little comment about management now.
Just a quick point, and this is not a substantive change from the old act, but it's kind of a blessing of flexibility that we've had in LLCs for quite some time. There is a specific statutory right now for a member in a member-managed LLC or a manager in a manager-managed LLC to delegate authority to a board of directors, board of managers, to officers, whatever. And we have used that quite extensively this year in setting up new LLCs where, for example, the client wants to adopt a corporate management structure. We have specifically had the members delegate their authority to manage to a board of directors or board of managers, whatever you want to call it. And we've also granted the authority to the board to appoint officers so that you can superimpose on an LLC a corporate-style governance structure if you want to do it. Most don't do that, but some do want to go through those formalities. And in dealing with the public, if you have somebody signing as president or whatever, then that's, everybody knows what that means, and you have that flexibility to do it. Don't have to, but it's specifically blessed now in the new statute.
Steve,
Yes.
Are you requiring a lot of the ones that you've already done agreements on to redo them now? The statement of authority?
I'm not requiring any client to redo his LLC, but we are strongly suggesting that they need to take a look at them and consult with us or other legal counsel and to look at them. I would say, and I was going to talk about this later, there are probably a lot of single-member LLCs that really there's no reason to change. But I would say with most multi-member LLCs, especially if they're member-managed, because of the elimination of the concept of a managing member, they really need to think hard about amending it. If it's a manager-managed LLC and you had an operating agreement and you've addressed most of the provisions, they probably don't need amendment. But in those specific cases, and again, you do need to look because now you got all these non-waivable provisions that you didn't have before, and what if your operating agreement addressed one of those non-waivable provisions by waiving it, and now it's not effective, it'll be in there, but it wouldn't be enforceable. So you'd probably want the members to understand that and reflect that in the operating agreement. And I will say, just to add to Charlie's comment, not a lot of LLCs appoint officers and so forth, but I think there is a subset of folks out there or businesses out there that are more comfortable with the corporate structure and dealing with officers, and they like to see officers even if it's an LLC. Let's see, okay. Amendment of the operating agreement and actually articles of organization. This is just something else. Again, if you haven't specifically provided for it in your operating agreement or in your articles, the default rule, well, it really wasn't addressed in the current act. The conclusion was if you wanted to amend the articles of amend the articles of organization or the operating agreement, that it could pretty much be done. I'm going the wrong way. Okay. There we go. It could be done by a majority in interest of the profits of the LLC. The new act changes that default rule altogether and says, look, unless otherwise provided in the articles or the operating agreement, it requires unanimous consent to amend an operating agreement or your articles of organization, which I think is the better rule, because most people, when they sign a contract, expect that it can't be amended without their consent. So that will be the new rule under the new LLC Act. All right, now we get to an area that I think is particularly interesting, and that's the duty of loyalty, the standard of care, and the standard of conduct for both members and managers of manager-manager LLCs and member-manager LLCs. And I just want to skip ahead a little bit and say, well, what is this duty of loyalty? Well, the duty of loyalty, which I have listed on page 9, is basically the duty of a member or manager, if he's subject to the duty of loyalty, which I'm going to have Ed Waters, one of our new tax associates, talk about in a minute, to really account for any profits or property attributable to the LLC. You can't really appropriate a corporate opportunity that would otherwise belong to the corporation. Additionally, and probably most importantly, is the last one that I've got highlighted there. Under the duty of loyalty, there is imposed an obligation to refrain from competing with the LLC with respect to its business until that LLC has been dissolved. So basically, any member or manager who happens to be subject to a duty of loyalty has this, I would call, kind of an ambiguous statutory non-compete, because there's no scope, there's no specific directions, but it's certainly something that could be used if a member left. And what I want to talk about now, so just keep in mind that the duty not to compete is important and it's statutorily imposed. And what I'm going to have Ed do, Ed Waters, is come up here and tell you who the duty of loyalty applies to, both respect to manager-manager LLCs and member-manager LLCs, and the differences, and there are slight differences between existing law and the new law.
As Steve has pointed out a couple of times, the concept of managing members in member-managed LLCs is going away with the new act. And as it currently stands, the duty of loyalty for member-managed LLCs applies to managing members, but the statute is silent as to other members, to who the duty will apply to. However, the new act, and I don't know if it's anywhere here on the slides, there it is. Yep. The new act will apply not to managing members, because managing members no longer exist, but the duty of loyalty now applies to all members of a member-managed LLC. As a result, on January 1st, 2015, when the ball drops and the year turns, surprise, if you're a member of a member-managed LLC and you weren't a managing member before, you now are included in the statutory duty of loyalty. And as Steve has already pointed out, that's particularly important because the duty of loyalty does include a non-compete. So for LLCs that were created before this year and had managing members on January 1st, 2015, those members now statutorily cannot compete against the LLC to which they are a member of. Big change. The other change, and there's two principal differences, the first being who the duty of loyalty applies to. The other big change is how you're able to, whether you can eliminate, amend, alter the duty of loyalty within your operating agreement. Currently, the duty of loyalty cannot completely be eliminated from the operating agreement. What the operating agreement can do is identify specific types of categories or activities that do not violate the duty of loyalty, if not manifestly unreasonable, and specify the number or percentage of members or disinterested managers that may authorize or ratify, after full disclosure of all material facts, a specific act or transaction that otherwise would violate the duty of loyalty. However, in the new LLC Act, the duty of loyalty can be eliminated via the operating agreement. However, in order to eliminate the duty of loyalty, the elimination cannot be, quote, unquote, manifestly unreasonable. That is defined in the statute as well, and the statute basically defines
Maybe going backwards, yeah.
I don't know which way I'm
Well,
going.
there you go.
Okay, whatever. The statute defines manifestly unreasonable as it being readily apparent that the objective of the term is unreasonable, or the term is an unreasonable means to achieve the provision's objective.
And just that decision is made by a court and not by a jury.
As a matter of law. So whether or not the elimination was manifestly unreasonable, as Steve just mentioned, is determined by the court and not by the jury. So those are the two big changes to the duty of loyalty to keep in mind, that if you're a member of a member-managed LLC, you were not previously a manager, or excuse me, a managing member of that LLC, you will have the duty of loyalty imposed upon you. Included among that is the duty not to compete. So importantly, from now on, it should be addressed in the operating agreement what entails that duty not to compete. Whether or not you want to eliminate it, if not manifestly unreasonable, that's fine. But currently, the statutory non-compete is unclear. So it's worth noting in the operating agreement.
Thank you, Ed. And I think that really the last concept that he was talking about modification or elimination. Well, first of all, before I go to that, one thing you can't do in altering the duty of care is you can't authorize acts of bad faith, willful or intentional misconduct, or knowing violation of law. And that's kind of what the cartoon shows here. He says, I told you a former LLC wouldn't protect us from our bad acts. So anyway, just to summarize, think about this. Under existing law, under new law effective January 1, 2015, managers are subject to the duty of loyalty if it's a manager-managed LLC. Members are not. They're not subject to that statutory non-compete. You may want to impose that on them, so you have to expressly do it in the operating agreement. Likewise, if you want to eliminate the non-compete, which many times you might have a couple of buddies get together, they form an LLC, they buy one commercial piece of property, and they don't want to be, prohibited from entering into or buying another piece of property by themselves or with other people. So you might want to eliminate that concept altogether. So you need to expressly provide it. It's a very important drafting issue to provide for the non-compete and spell it out. Plus the statutory non-compete is hard to define.
One quick point to underscore, and I really think the legislature dropped the ball on this non-compete. If you're member managed and you don't provide otherwise, you will have a non-compete superimposed on your LLC. The problem is, what is the scope of the non-compete? What's the geographic limit? What's the time frame? Does it extend beyond the time than when you were a member? You're leaving all this up in the air if you don't deal with this. So, I mean, what Steve mentioned for multi-member, particularly as manager-managed, but, you know, if you want the non-compete on the members, you got to provide for that. But that's one of the things you definitely want to go back and look at and think about. Where do we stand now under the new act? Because we might have something imposed on us and we don't even know what it is.
That's exactly right, and that's the whole point of this, this PowerPoint, because it's a drafting note that this is something you need to expressly address whichever way you want to go with it. And you want to specify terms because we have no idea what the scope of the statutory non-compete is. Moving on, closely related to the duty of loyalty is conflict of interest transactions. The change, probably the most important change, was under existing law, it appeared that as long as there was full disclosure to the disinterested members and managers, and they approved the transaction, then the transaction was not subject to challenge, and even if it wasn't necessarily, quote, fair to the LLC. Well, that's changed under the new act. Even if you've given full disclosure, you've got consent of the disinterested parties, unless the transaction is fair to the LLC, it is not necessarily enforceable. And they basically, fair to LLC means, would it be the same type of transaction that you would enter into with an unrelated third party in an arm's length transaction? Now we're going to get a little bit into records, and I'm not going to spend a lot of time on this, but I like this cartoon. The lady's asking, well, I want to inspect all the books and records of the LLC, and then either the accountant or the attorney saying, well, sorry, you got to look at the operating agreement first to see how we've limited your rights. So again, you need to look. You can put reasonable restrictions on those inspection rights of books and records. And also, really new under the Florida Revised LLC Act is different rules apply to manager-managed versus member-managed LLCs. Member-managed LLC, basically there's a list of records that those members have unlimited access to, and then other records they just need to show that they have those records are material to their members' rights and duties under the operating agreement. It's a looser standard. In a manager-managed LLC, of course, the managers have pretty full inspection rights, but members actually have to file kind of a written request, or they call it a record, and basically asking, number one, specifying what they're seeking, why they're seeking, and whether that information is directly related to the purpose for which they're seeking the information. So a little bit higher standard to get to records in a manager-managed LLC if you're just a member. The concept of transferable interest. Again, this is one of the new definitions under the Act. Previously, the definition was just for that of an interest. Well, the definition of a transferable interest under the new Act really just means the transferee's rights to distributions. It does not include the rights to vote or participate in the management of the LLC, whereas the definition of an interest encompassed all of those rights. So under the existing law, the transferee has the right to receive distributions and share in profits and losses and allocations of income and gain or similar items, okay? So in addition to a transferee having right to distributions, the existing statute specifically talked about rights to allocations of profits, losses, income deduction, and credit. The new Act changes that and only reflects or only comments on, as a transferee, you have the right to the distributions to which the member would have been entitled. It is silent as to the rights of allocations of profits or losses from the LLC. And where this gets important is really from a tax perspective. One of the things we always tried to tout, one of the advantages of the LLC was you can just get a charging order, only gives you rights to distributions. We all know that. And the other thing we always would try to argue that made it a weak remedy was that, well, gee, you could potentially, as transferee, be subject to your share of income even if no distributions are made. Well, I think that's less likely to happen under the new act because it no longer refers to the transferee having the right to allocations of profits or losses. It leaves it just up in the air, more or less. So, again, probably as far as the LLC goes, I would call that one probably a negative change. Charging orders, as I said before, I'm just going to go over dissociation. That's a concept with which has been kind of very vague to all of us. But the thing to keep in mind about dissociation is under existing law, there were only certain specified events that would allow a member to, quote, disassociate himself from the LLC. Now there's a whole plethora of reasons a member can disassociate or be disassociated by the other members from the LLC. And one of those is to disassociate by express will, as this points out. So I, as a member, can say, I'm disassociating. You can't vary this. The operating agreement can't prevent you from disassociating. Well, if it's a wrongful disassociation, because the operating agreement basically provides you can't disassociate it, you will be liable potentially for damages as a result of the wrongful disassociation. I don't know how those damages are determined, so that's kind of left up in the air. But once you've dissociated, again, your rights are to distributions. You lose the right to management, the right to vote. But also, and I think this is important, disassociation can be used. Say you're in a member-managed LLC, and you don't have any statement of authority or anything, so you're subject to the duty of loyalty. And you can, again, in an operating agreement, you can actually also, we didn't mention when we were talking about it, in a member-managed LLC, you can specifically assign duties to one member and relieve a member of those duties. So a member could be relieved of the duty of loyalty if it's specifically and expressly set forth in your operating agreement. However, if you haven't done that, and so you're sitting here as a member of a member-managed LLC, you're subject to the duty of loyalty by doing a disassociation by express will. Although you could be liable for damages and you're not going to have any right to participate in management, it also eliminates your duties of loyalty and your management obligations to the LLC. So, that could be used affirmatively by a member to his favor.
This is what we used to call an assignee. If you were a substitute member, meaning you stepped into the shoes of your transferor, you had all the rights of a member. If you were an assignee under the old act, then you had only the right to receive distributions at liquidation or current distributions, and you'll be allocated your share of profits and so forth. Steve has pointed out some of the problems associated with this. It's a new term that defines an old concept, but the concept's been changed a little bit. What we're doing now in our LLC agreements is providing that, first of all, a definition of transferable interest, which kind of dovetails on the statute, but I add that the holder of a transferable interest will be allocated the same amount of profits that person or the transferor was to be allocated with respect to that particular membership interest. The holder of the transferable interest will be liable for making any capital contributions to which the transferor was obligated to make, to clarify that, so that we know that not only you're going to receive your 10% share of distributions, you're going to get your 10% share of profits allocated to you. I would argue under subchapter K that's the result you'd have anyway, because if you're getting the economic benefit, the tax law has to make those profits tie in with the economic benefits, but that's not clear in the statute, as Steve pointed out. I think it has to be that, but who knows? It's up in the air. It's better that you draft to deal with these issues in advance so that there's no uncertainty. And when somebody is the holder of a transferable interest, if they dissociate wrongfully, they will automatically be deemed to be holding a transferable interest. And it's good to be able to say, here is the package of rights and here are the limitations that are superimposed upon that person as a holder of a transferable interest.
Yeah, and just to emphasize, I mean, I think somebody could argue because the old act had the language in it about allocation of profits. New act doesn't. You know, at least they could try to argue I shouldn't be allocated my share of the profits. So you definitely, it's silent, so it's something you can address in the operating agreement and something you should address in the operating agreement. And again, it makes that charging order remedy and just it makes it fair. You want those profits allocated if he's going to be getting the distributions, as Charlie said. Judicial dissolution, I have about 5 minutes, I think, left before I turn it over to Jane. The judicial dissolution procedures in the new act added really 3 new causes of action for which a judicial dissolution could be sought. That is, the LLC's activities are unlawful, not reasonably practical to carry on in conformity with the operating agreement, and the controlling, probably most importantly, the controlling members or managers have acted illegally or fraudulently. So that's a basis for a member to bring an action for judicial dissolution. Additionally, they carry over the 2 existing things where the company's assets are being wasted or misappropriated, as well as if there's a deadlock. Now, what I want to specifically talk about, though, very important, although I don't have it on the slides, in the outline, page 14, the existing LLC Act gave creditors a right to petition a court for judicial dissolution. That has been taken out of the new act. Creditors cannot do that. So that's at least a favorable change for the members. Deadlock sales provisions. What the new act provides is that if you have an express provision in your agreement that deals with situations of deadlock, and this is many times when we have LLCs that are owned 50-50 by members, that if you have that deadlock provision, that controls or trumps any action for a judicial dissolution based on deadlock. So you can rely on that. And a deadlock provision is really basically any type of provision that changes or that provides a solution to breaking the deadlock. And again, so he was basically talking about what I refer to as a Russian roulette provision. They're also called, Texas something provisions. But, you know, one partner has the burden, he comes up with the price, and the other partner has the right to either purchase at that price or sell at that price. And again, highly suggest that in cases where a deadlock is possible. Another new concept that's been added, that's been borrowed from the corporate statutes, is now if there is a judicial action brought by a member to dissolve the corporation, the LLC and or the remaining members, instead of going through with the dissolution, actually have the option to buy the interest of the member who brought the petition to dissolve the LLC. Again, that's a provision that's in the corporate statutes, and now it's in the LLC statutes. Very briefly, mergers, conversions, and appraisal rights. I do want to mention these. Currently, existing law really only deals with conversions of LLCs into other types of entities and mergers of LLCs into other types of entities. What the new act introduces is, again, some concepts from corporations, interest exchanges, and I guess I ought to move on to that. Importantly, though, let me mention this, too. The new act clarifies that with respect to a merger, if you're a non-voting member, you do not have the right to vote on whether or not the corporation merges. And that is something that apparently was not entirely clear under the existing act. All right, so they add this new way of affiliating a Florida LLC with another entity. It's called interest exchanges. I'm not going to go through that. They also add a new provision about domesticating foreign LLCs, where they get to keep their foreign classification but become a Florida LLC. That leads us really to my last area, and it's appraisal rights. And there's really two main changes made to appraisal rights, but these are important. Under existing law, a member has an appraisal right. That is, the right to demand the fair value of his membership interest only upon the happening of two occurrences: if the LLC merges or the LLC converts. Then that member has the right to demand his, quote, appraisal rights, instead of going along with the merger or conversion, to be paid the fair value of his shares. They've added a number, like 5 additional reasons, the most important of which really is, because this is the consummation of a sale of substantially all the assets of an LLC. Now, if a member doesn't want to go along with that, he can demand appraisal rights, and I think that's very important. That's what I said. It now applies to a much broader class of transactions. I'm not going to go through all of them because of time. Waiver of appraisal rights, again, very important. The Florida Act, this is not a non-waivable provision. If you provide in your operating agreement, and all the members sign it, that we waive our right to appraisal rights, then that's effective, and they will not have any appraisal rights upon the occurrence of one of these triggering events. One of the things that we've kicked around before, because we've had a question on this, we typically would have provisions such as drag-along provisions that would say if the majority member wants to sell his stock or wants to sell the assets or enter into a merger, he could drag along the minority LLC member as long as the minority LLC member got the same terms and conditions. And I guess the question is that enough in and of itself to waive appraisal rights? Probably, but I wouldn't take the chance. Again, if I had a drag-along provision, I would also have an express provision that the members are waiving their appraisal rights. The last point is the determination of fair value, and this is very interesting. As far as the fair value goes, in determining, okay, I've objected to one of these transactions. Maybe it's a merger. I have appraisal rights, they haven't been waived, so I have the right to be paid the fair value of my membership interest. Well, under the new LLC Act, they have eliminated the concept of applying minority or marketability discounts, which used to apply to any LLC having more than 10 members. And I think the interesting thing about that is that provision about marketability and minority interest discounts in determining fair value with respect to these appraisal or dissenters' rights is still in the corporate statute. So this could actually be might be a factor you want to consider in making a choice of entity in an LLC versus a corporation, because you still have the right to apply that discount if you have more than 10 shareholders and you're doing a merger or other transaction with respect to corporations. With that, I'm going to go ahead and turn it over to Jane. She's going to talk a little bit about the LLC Act and application to nonprofits, and then talk about the social benefit corporations, social purpose corporations, and benefit corporations. Jane?
Right. Thanks, Steve. I'm going to finish out the new LLC Act just briefly to talk about some provisions that are relevant for nonprofit or charitable organizations when they consider using LLCs in their in what they do. There's a couple of things in the new LLC Act that are specific to charitable organizations. The first one is They're good. The first one is that the new law will prevent a nonprofit LLC from using the LLC Act to avoid restrictions on property that was contributed for a charitable purpose. And so that's this first topic of preservation of charitable gifts. More importantly, though, for charitable organizations that use LLCs are that the new law clarifies that an LLC can be a nonprofit entity or a charitable entity. Some states still require that an LLC be used for a business purpose. The old law that's been in Chapter 608, the repealed law, did provide for an LLC to be used for any lawful purpose. And so based on that, we've been using LLCs as, say, single-member LLCs of charitable organizations, so of 501c3 organizations, for the duration of this LLC statute, as the federal tax law has allowed us to do so. So even the old law, it was our view that it permitted a Section 501c3 organization to use a single member LLC for a charitable purpose, but now the new law is more specific and states that a limited liability company may have any lawful purpose regardless of whether the company is a for-profit company. So just clarifying that. And the uniform law comment to this LLC Act similarly states that the phrase any lawful purpose, regardless of whether for profit, encompasses even charitable activities. And the reason that we care about this ability to use a single member LLC by a 501c3 organization is that it's a great vehicle for a lot of C3s to consider when they have an activity that looks like it should be held in a separate entity. So the nice thing about using a single member LLC is that for federal tax purposes, it's a disregarded entity, and it's simply treated as a division of the 501c3 organization. So this is in alignment with regular law on what a single member LLC is. It's a disregarded entity. But the effect of that is that the organization does not have to file the Form 1023 with the IRS, which is the application for recognition of exemption under 501c3. It just automatically has the status of its parent organization. It also does not have a separate Form 990 filing requirement because, again, for federal tax purposes, it's treated as a division of the 501c3 organization. So all those activities just go on the parent's Form 990. So it's a really nice vehicle for a 501c3 organization to put a related activity into the LLC, or in some circumstances, even an unrelated activity, if they don't mind filing the Form 990T to report the taxable income. But again, so the change in the Florida law just confirms that that LLC can be used for that purpose. In any case, though, it's important to keep in mind that even though the single member LLC is a disregarded entity for federal tax purposes, that it's still a separate entity for state law purposes. So consider state law exemptions, such as sales tax and ad valorem property tax exemptions for your single member LLC of a 501c3 organization, and make sure that what you're doing in your LLC will qualify for those exemptions, and make the applications that you need to make. And I guess I'll tack on to that comment also the Florida Solicitation of Contributions Act registration. If your LLC is being formed for a fundraising purpose of a 501c3 or otherwise will be doing any fundraising, again, as a separate entity, it will have that registration requirement under Florida law for solicitation of contributions. So those are those couple of minor changes to the LLC Act are relevant for our 501c3 organizations and other classifications of tax-exempt organizations. And now I want to talk for a little bit about a whole new set of laws in the Florida law regarding the social purpose corporations and benefit corporations. This is new in our Florida law. We have not had these types of corporations authorized in Florida law before, and the law was effective July 1, 2014. And I have some props for you to think about while I'm talking a little bit about these two new types of organizations. I don't know if you can all see this, but I'm putting out some they're not all organic, but they all came out of my house. So I think it's relevant to know that these organizations that I'm going to talk about are making an impact in the way they're operating their businesses. So I'm putting out a couple of things of 7th generation soaps. I'm going to put up here a bag of King Arthur flour. It is 100% organic, unbleached. A couple of my Patagonia items. I am a skier, and so I have some Patagonia ski clothes. And also some Badger Sleep Balm, B-A-L-M, balm. So what are these things? We have 2 new types of corporations. They are for-profit corporations, taxable, and they are created under Chapter 607. Right now, or before the enactment of this law, the 2 types of corporations we had in Florida were for-profit under Chapter 607 and not-for-profit under Chapter 617. The for-profit corporations have directors that have a duty to manage the corporation assets for profit, whereas the Chapter 617 organizations must have a not-for-profit purpose, and the statute lists a group of purposes that they might have: charitable, civic, trade association, various types of nonprofit purposes. The 2 new types of corporations, again, they're both taxable for-profit corporations, and they're in Chapter 607. So they're in the same statute that currently houses our other regular corporations. And what the legislature did is now there's 3 parts to Chapter 607. There used to just be 1 chapter with everything in there about a taxable or a regular for-profit corporation. Now, Part 1 has all those old provisions. Part 2 has the social purpose corporations provisions, and Part 3 has the benefit corporations section. Now, the Part 2 and Part 3, they're really similar. I mean, you can lay them side by side, and they, in many aspects, are exactly the same. So I think that when they went back through, they might have just forgotten to line them up all the way through. But the primary difference between these organizations and a regular taxable corporation are 2. One is that these new corporations can have purposes that are for the public benefit. So not just the purpose of maximizing profits for their shareholders, but they can have a purpose of providing some sort of public benefit. And the other thing that makes them different from regular corporations is kind of a transparency concept. These new organizations have to file an annual benefit report that talks about what they've done for the public good, and they're available in the public. To anybody who wants them, they have to post them up on their websites. So before our law did not have a provision that would allow a corporation to have this public benefit purpose while still protecting the directors from a claim that they weren't operating to maximize profits. The legislative history has an example back from 1917 when Henry Ford declared that he wanted to employ more people to spread the benefits of the industrial system to the greatest possible number, help them build up their lives, etc. And to do that, to plow back the profits into his business, the shareholders sued and won, saying that the profits had to be paid to the shareholders. So a number of years later, we're now back to this concept of, can a corporation operate for the public benefit and not just for the benefit of the shareholders? Of course, many corporations have been doing this for years. It's a part of how they think it's a good way to make a profit, is to be seen in their communities and so forth. But these new statutes, the first one allows for a social purpose corporation. We've added a, oh no, I'm doing the same thing. They've added for corporate purposes. In addition to the regular corporate purposes, these also create a public benefit. There's a definition of public benefit in the statute that if you read them, now for the social purpose corporation, they list a lot of specific things. So a positive effect on like the environment, artistic, charitable, economic type topics. So they have some specific topics for social purpose corporations. And I've listed those as well, some of those specific topics that a social purpose corporation can cover. Then the directors of these types of corporations, the statute, here's a difference between the two types of corporations, both those purposes and then this set. The statute says what the directors shall consider and what they may consider, and here they shall consider both the shareholders and the ability of the corporation to accomplish its public benefit. Or it also could specify what those benefits are. And then they may consider this other group of topics like employees, suppliers, their community, their environment. So let's look at the second type of new corporation, the benefit corporation. It will have as its corporate purpose, in addition to the regular corporate purposes already allowed, creating a general public benefit. And there's a definition of general public benefit, a material positive effect on society and the environment, taken as a whole, as assessed using a third-party standard attributable to the business and operations of the corporation. So here's the difference with this type of corporation. Now we actually have to use a third-party standard to evaluate whether the corporation is accomplishing a public benefit. And here's another difference here is the statute has a list of things that the director shall consider for the benefit corporation. Everything, the shareholders, the environment, the customers, the global community, et cetera. There's quite a long list of things that the statute requires the directors to consider for the benefit corporation. Both types of corporations file an annual benefit report. This is the kind of new transparency part of both of these types of corporations, and it will contain a narrative description of the ways that the corporations have accomplished their public benefit. And again, for the social purpose corporation, they don't have to use any kind of standard for creating their report, whereas the benefit corporations do have to use some sort of a third-party standard. So these annual benefit reports are public record. The corporation has to put it on their website if they have one, and otherwise they have to provide it to people that ask for it. The organizations can have a benefit director or a benefit officer that kind of tracks these things for the corporation. They're not required to, but they may. Also, even though it sounds great that these corporations are set up for these particular purposes, you can't go in and say, oh, I don't think you're doing it. I'm gonna sue you because I don't think you're doing the right thing. I don't think you're accomplishing your public benefit or your social purpose. The right of action to bring that kind of an action against the corporation to say that they're not fulfilling their purpose is limited to the shareholders in a derivative action or by the corporation itself. I mentioned that the benefit corporations have to use a third-party standard for creating their annual benefit report. The social purpose corporations may if they want to, and I've just listed a few examples of what might constitute a third-party standard. The problem is that this covers all industries. Professional corporations can choose to convert to be one of these types of corporations if they want to. So the standards would be whatever would apply in your industry. So it's, there's just a few here, including the B Lab assessment and the Green Seal business certification. And so let's talk for just a minute as I'm winding up on certification. Certification is not required for either of these types of corporations, but many choose to obtain a certification. And so, for example, the B certification is provided by B Lab, and that certification is provided to B corporations, or you don't have to be a benefit corporation, but they're provided to corporations that apply through the B Lab to get this certification. And in order to obtain that certification, the organization has to go through another set of review by the B Lab. And so these products are all being produced by companies that have the B Corporation certification, the B Corp certification. And again, this is completely outside of Florida law, and none of these corporations, the social purpose corporation and the benefit corporation, would not have to get these certifications. But the certifications, they may use that for marketing and say, look what we do. And there's an additional transparency piece for these organizations. They have to complete assessments with the certifying organization, and then I printed out the little report for each one of the products I have, and it covers the same sorts of things that I just breezed through that a benefit corporation would look at under Florida law, like environment. There's a group of environmental factors, workers, the status of their workers, worker ownership, work environment, community, how much of an impact the organization has in their community, including on suppliers and distributors and job creation, and also a governance category. So this certification, again, is separate from Florida law, but is available to corporations that are interested in social benefit and feel like there's a good benefit to getting this certification and maintaining the certification. Both Steve and I would be happy to answer any questions on the new LLC Act or on these new corporate structures. You also should have received a valuation form when you came in. Please fill that out as well. Oh, I can talk some more about benefit corporations. Yes.
And just tell them if they want to come up afterwards, they can talk to us.
Yes. Karen, do you have the CLE information? Do you have CLE? Sorry. Yes.
A certificate of authority be assigned to any third party, or do they have to be a member or manager?
The statement of authority, I think you can designate any person you want to act on behalf of the corporation, and it's going to be binding. I don't think it has to be a member or a man. Just like a manager does not have to be a member of an LLC, I think that same principle applies. Yeah, well, what?
Liz.
Can the B Corps, do they have to promise that they'll never file for bankruptcy?
She said, can the B Corporation promise to never file for bankruptcy? I think it's sort of outside of their hands, so I would say no.
I just wanted to make one comment on Jane's presentation. She brought these props, but Ben & Jerry's recently sold to a third party and to another company, that is. And they were not a benefit corporation at that time, but they converted to a benefit corporation. So one, I was hoping we'd get samples of Ben & Jerry's, but we didn't. But two, a really interesting question that comes up is, if you have a for-profit corporation acquire one of these B corporations, can the shareholders of the for-profit corporation bring some kind of action that these guys shouldn't have acquired a B corporation or converted to B corporation status because it's not maximizing the profits of the holding company?
A number of these B corporations actually are showing up as wholly owned subsidiaries of publicly traded companies. So we'll see how that shakes out. I don't believe that there are any U.S. publicly traded B corporations at this point, and it doesn't really make sense that you would be a publicly traded company and not maximize profits to your shareholder. But I did see one Canadian publicly traded B corporation.
If you want to read about a corporation like none other, read about King Arthur Flour, which started in 1790 in Boston. That's number one. And in 1990, it converted to 1996. It converted to ESOP ownership. So if you talk about the fiduciary duties, of a corporate B corporation being overridden by the statute, you've got the trustee who has a fiduciary duty to maximize the return for retirement. And how does that impact the B status? But nonetheless, in 2008, King Arthur converted from regular corporation to B.
So the comment there is that this King Arthur flour, this is the oldest flour company in the U.S., which I only learned when I was kind of looking them up, and it's the only organic flour that Publix, my little Publix carries. So this is actually what I buy. And the point here was that the thing is now owned by an ESOP. And how is that B corporation status consistent with ESOP ownership with a trustee who's obligated to maximize the returns for the ESOP? So a lot of these organizations, though, will say that their business practices are more profitable, particularly in the long run. So as they work in their communities and work with sustainable practices and maybe green buildings and different things, that over time that they will actually be more profitable, which may be how the B corporation ends up being owned by the ESOP. And I brought also one of my other favorite products, a Life is Good bag. And it is not a B corporation. It's a closely held company. And I just brought that to point out that there's so many options for corporations that want to have a social purpose and have a strong social benefit, that if these are two brothers, if they own their own company, they can do whatever they want. They don't need to be a B corporation.
Okay, and just to conclude, I think the two major advantages of these B corporations and the special social purpose corporations are, one, I think marketing, number one. It helps you in marketing potentially, that you're socially conscious. And two, of course, it protects the directors from, a breach of fiduciary duties because they're not maximizing profits, but but also serving the social purpose. Anyway, I want to thank you all for taking your time, your valuable time to be here, and we appreciate it very much.